Hello, and welcome to the Gonzalez Mitchell Show. I'm Clay Mitchell.
And I'm Patrick Gonzalez.
And today, our special guest is Phil Goldberg. He is special counsel to the Manufacturers Accountability Project. And he was recently immersed in a lawsuit, local lawsuits, over climate change, remarkably. Phil, welcome to the show.
Well, thank you, Clayton and Patrick. It's really good to be with you both and talking to your audience today about an issue that maybe most people haven't heard of or thought about, but something that would affect everybody, that's listening to this show. So I appreciate being here. Thank you.
Now, explain to me that the plaintiffs obviously filed all these lawsuits uh, over a couple dozen energy companies. What is the cause of action here, and what's their theory of the case?
Yeah, that's a great question. And honestly, it keeps shifting and moving. I've referred to this as throwing legal spaghetti on the wall and seeing what sticks. Essentially, you've got a bunch of communities around the country, not just here in Maryland, that are suing energy producers, saying that because their products, in terms of the fuels, lead to greenhouse gas emissions, that they've caused climate change, and that as a result these various entities can sue them for what they claim are their injuries from climate change. And that's just not how the law works. And that's what the Maryland Supreme Court said in its ruling a couple weeks ago, is that that's not, both it's not an issue of state tort law or state liability law. Our Maryland law doesn't reach to interstate or international emissions issues. And then on top of that, these are federal law issues, and so so the federal law in this situation would preempt the right of any state to make these kinds of decisions. And it was a very thorough and thoughtful decision by the Maryland Supreme Court, and we filed an amicus brief in the case on behalf of the National Association of Manufacturers. That's what this project I work on is housed under the NAM. And so we filed an amicus brief in the case, kind of explaining all of this and why this is not a liability issue for the courts. Climate change is a very important issue, something we very much need to deal with, but it's a public policy issue for state legislatures, for the Congress, for agencies. It's not something that you can decide through courts and having individual judges around the country deciding who should be liable for climate change and under what conditions. It's something that has to be addressed at a federal and even international level.
Patrick, what are you thinking?
Well, Phil, help clue me in. As I understand it, the climate's been changing for 4.5 billion years. Is that correct?
I'm not a scientist, but I take your word for it, Patrick.
Okay, so you're saying you said your words, climate change is a serious issue. What caused the climate to change that destroyed the dinosaurs about 3 billion years ago?
Well, if I had to answer from what I learned in school, would have been an asteroid hit the Earth. But you might have a different answer. I'm not entirely sure.
That sounds about right. So honestly, if we continue to burn fossil fuel, as has been spoken by many politicians, is the world going to end in 6, 8, 12 years?
Well, our issue with this litigation is really not about the underlying science. It's not about whether climate change is real or not real. All of the major energy companies since at least 2008 have been acknowledging that their products do emit greenhouse gas emissions. The carbon is part of that. So that's not what we're really focused on in this litigation. What we're focused on is, okay, assume that all to be true. What is it that we're doing to try to solve the problem, and how do we go forward and reduce emissions to the point that we can make life here sustainable, both for those of us on the planet, but then also for the planet itself. And so that's really what we're focused on. And when you deal with lawsuits, you're trying to say it's somebody else's fault. We're trying to blame somebody else for this situation, where what courts have been saying is that greenhouse gas emissions is part of modern lifestyle. It's part of all of us heating our homes and driving our cars and doing all the things that we do every day. And it's been happening for at these levels for 100 to 150 years at the very least, maybe more. Patrick, I'm not suggesting that we're limited to that, but and that there are theories that then everything goes up in the atmosphere and mixes together, and then that causes these effects on the Earth. And so when you're dealing with something that really anybody can be a defendant, anybody can be a plaintiff, there's something that's ubiquitous that's happening around the world. You don't have the liability measures and like the rules that govern liability law, that govern who's liable to whom for how much and why. Those laws don't apply to this kind of situation because there's no discrete act or injury that anybody can sue for that's unique to them, or that at least is like within the realm of what tort law or what liability law typically deals with. That's the problem with these lawsuits, and that's what the Maryland Supreme Court said. Is that there's no liability law we have in our books in Maryland that allows these local governments to sue energy companies for something that's happening all over the world and has been for hundreds of years.
Not to geek out on everybody,
Mhm.
but when the plaintiffs filed their lawsuit, under what tort law did they try to say that there were damages?
Yeah, that's a great question, Clayton. And I'm gonna, what's the expression about, without context, it's pretext. So I'll give you a little bit of context for this. So the first round of climate lawsuits like this one was filed back in 2004. And it was a bunch of states and New York City suing utilities at the time under what's called federal public nuisance law. And the Supreme Court back then in 2011, in this case called AP versus Connecticut, said there's no federal common law, there's no federal public nuisance law that be applied here. To the extent that there was, Congress has displaced it by enacting the Clean Air Act, and therefore they can't bring this case. They made a bunch of other comments in the ruling saying that the use of state law would be inappropriate, that that this is an issue of special federal interest. You're dealing with interstate or international emissions questions, which are not the focus of any individual state law. But that was what they called dicta. It was what the court said in explaining why they ruled on displacement of federal common law. And so in 2017, you started seeing Baltimore and a bunch of other local governments say, well, they didn't say specifically state tort law or state liability law wasn't allowed. So why don't we just bring these cases under this theory? And it's what's remarkable is you don't have to take my word for this. They actually all met at a lot of the people behind the litigation met in La Jolla, California in 2012 and said, okay, now what do we do? And so they said, well, if the U.S. Supreme Court said we can't sue the utility companies, which was then let's sue the product companies, the Exxons and the Chevrons and all those types of companies. So and then they said, well, if they said no federal law, well, let's sue under state law. If they said, well, you can't get injunctive relief in AEP, which is what they said, let's ask for damages. They just kind of just tried to move the deck chairs around a little bit to try to make it look different. But at the end of the day, this is the same case that was brought against AEP, irrespective of how they move the deck chairs around. And that's what, again, the Maryland Supreme Court said. That's what the U.S. Court of Appeals for the Second Circuit has said. A bunch of other courts have said this is the same case. It's no different than what was in AEP. And so for the same reasons that federal public nuisance law was not allowed in AEP, state public nuisance law, state private nuisance law, state trespass law, state Consumer Protection Act law, or state failure to warn law, none of that matters. It's all because these are all, these are really federal questions and they're public policy matters that, and the Supreme Court said that would be inappropriate for judges on an ad hoc basis to be deciding these energy issues. These are things that they said, it's a good thing that we have a federal agency, an expert agency, dedicated to this effort. So that's kind of why I want to give a little bit of background on. So the answer to your question, it's public nuisance, private nuisance, trespass, failure to warn, Consumer Protection Act. But there's a reason for that because they were trying to make it look different from AEP, even though they were trying to have the same effect that they were having, which is regulating oil and gas industry, not just within the state, but around the world.
And I guess, say for argument's sake that these lawsuits were allowed to go forward, it seems to me that you could have, say, a case with Baltimore City as the plaintiff, with Chicago as the plaintiff, or any of a number of jurisdictions. You could get inconsistent decisions in the courts, and all of a sudden you got this patchwork of different decisions on an issue that really, as you said, is global against these multinational companies. And I don't understand how they thought that was going to work when, as you said, the case really has been tried before. The issue has been litigated. The Supreme Courts have said, hey, there's no cause of action here. Just by having a patchwork of different decisions, how would anybody think that would work?
So Clayton, you're thinking like a lawyer. I like it. This is good. But they're thinking like a political campaign. So they're using the courts as an extension of their political campaign against the companies that they want to blame for climate change, or that they think aren't regulated enough, or to try to achieve in the courts what they couldn't achieve in the legislatures. And so a lot of this is just about bringing lawsuits and trying to use the public policy. Use the public relations aspects of litigation to be able to try to just associate in people's minds the idea that these companies are culpable for climate change, and that in of itself is a victory for them. And they've said that they want to create this some kind of scandal around all of this and try to make it something that it's not, as a way to advance their political agenda. And they've said, look, they've acknowledged that we look at the politics when we go around to these different local governments and ask them to sign up for one of these lawsuits. We're focusing on the politics of not just of what the local government is, but then who they might want to blame, and they look at what the politics are of the state legal climate. So they're bringing these cases in states they think there's a chance that at least one will succeed. So it's Maryland, it's Jersey, it's Delaware, it's Pennsylvania, it's Minnesota, Colorado, Hawaii. They've brought a few in like South Carolina, North Carolina. They've also Washington State and Oregon. So they're looking at where they think they can get favorable rulings, and they only have to get like one or two. They don't have to win all of these lawsuits. They get one or two of these lawsuits through, and right now Colorado and Hawaii have allowed the lawsuits. That's the Colorado one is on appeal to the U.S. Supreme Court. So we'll kind of see if the U.S. Supreme Court steps in and kind of says no, the way the Maryland Supreme Court did. But that's they only have to be successful once or twice, where the companies are defending these kind of have to win everywhere, or the whole thing just unravels in that regard.
Patrick, this has got to be driving you crazy. The politicization of the courts.
I'm not even going to go there. But Phil made a comment. They're acting like politicians talking about the Baltimore situation. I would argue they're acting like children. I mean, if you, as a leader or a figure in Baltimore, go ahead and sue some entity over the global climate crisis, then you don't have to address your own backyard. Baltimore City, physically, aesthetically, is a cesspool, and it has been for years. And whenever you drive through, or different parts of it, I can't imagine. It's like telling a child, hey, go clean up your room. And they start talking about all the comings and goings on at school and trying to distract, and their parents get off on this tangent and forget about cleaning up the room. I would suggest that the children, the politicians, instead of distracting, instead of diverting, just make your bed every morning. Just start with something simple. And whether it's Baltimore City or any other jurisdiction, just start with the basic, clean it up. If we care so much about the environment, make your bed. That'd be my comment.
Well, I'll say I do enjoy going out into Fells Point, and I do enjoy going to to Camden Yards. So I find Baltimore to be a fun place to go and to hang out. But the impact of this litigation is going to increase.
But
the cost.
Phil, do you have to drive by through certain areas that are a cesspool to get there? Yes or no?
Well, your knowledge of Baltimore certainly exceeds
Now,
mine.
your knowledge is fine. If you go to Fells Point in Camden Yards, okay, you're being polite. We
Yeah,
don't like
and
polite on this.
and the law school downtown. It's also I've enjoyed going there and doing a couple lectures or whatever it is. I enjoy Baltimore, but my point is the litigation itself is going to increase the cost of energy on people, right? And that is getting back to the answer, Clayton, to the question you asked before, is you have people on the who are associated and kind of part of the group of people behind these lawsuits acknowledging what they want to do is use these lawsuits to raise the price of energy because they think that there should be what one person on a program about a couple months ago said, a carbon tax. And this is, he called it this is
Right.
like kind of like a backdoor carbon tax, because they know if you make the energy companies pay all this money, what it really means is you're making the consumers pay all this money. And so it's going to become more expensive to do the basic things that everybody does in order to power their everyday lives. And that's true for the people in Baltimore, and it's true for the people outside of Baltimore. And that's one of the concerns that a lot of people have for this litigation is that, if say Baltimore got money from it, first of all, it's going to raise the price of energy on, on Baltimore residents to really pay for that. But then it's going to raise the price of energy for everybody around Maryland, not just in Baltimore, not just in Annapolis or Anne Arundel County. It's going to raise the price of energy for everybody because the companies can't just charge more in Baltimore, more in Anne Arundel. They're going to have to charge more everywhere in order to pay for all of this. And so that's one of the real downsides, and one of the reasons the manufacturing community is behind, is opposed to this litigation, because manufacturers on the one hand are energy consumers. They, and this would drive up the cost of energy and make manufacturers less competitive internationally against those who don't have to pay for these higher rates. But then also, the manufacturers are concerned that if that's the answer to this question, right, this public policy question, then there are other public policy imperatives that are going to come up, and it's just going to be, oh, well, just sue the companies that are involved in that industry, even if it's not their fault, even if they didn't do anything wrong, even if they didn't violate any tort law, if they didn't do whatever it is that they're being alleged, it's just going to be, well, these are too hard political issues. We can't come to any kind of resolution on them. So let's, so let's just sue the companies and try to get the change or the money, frankly, that we would like to get directly from them. And that's not the right use of the court system in Maryland or any other
Right.
place.
Now, you mentioned that there's a case out of Colorado. Maybe there's lawsuits going forward in Hawaii and some other states. Talk to me about what would the result be if the Supreme Court decided in your favor versus against you and said, nope, these can go on. What would the damage to the industry and to the regulatory fiber of greenhouse gas emissions and utility industries? What would that be? What would the impact be?
Well, I mean, I said the impact would be it would cost people a lot more money to do the basic things they have to do every day in terms of powering their lives. But the question, I think it's a little bit more nuanced. It's what is the Supreme Court rule? Because they took the Boulder case, and how, and like in 2011 when the Supreme Court thought it kind of did away with these cases, and the people behind them kind of figured out, okay, now what other legal spaghetti can we throw on the wall? They'll probably do the same thing here. So the question would be, how strong is the Supreme Court ruling, not just saying this is a matter of federal law versus a matter of state law, but also about the idea of subjecting energy companies to liability for climate change, or any companies, not just energy companies,
Right.
liable for climate change, because we're seeing already, some cases like in Michigan are being brought under antitrust law. We're seeing cases in there was one in Puerto Rico which has since been dismissed. We're under a state RICO lawsuit, and they're trying every different legal theory that's out there to say, how about this one? How about this one? How about this one? And it's a long and expensive process for the courts to keep saying no. But they'll keep trying because, as I said before, this is really about their political agenda. It's not really about a liability issue. And so they're they're suing some places, one or two companies, some places a dozen companies, some places 3 dozen companies. Sometimes it's energy producers. Sometimes they add in some local, gas station to try to keep it in state court. They keep trying all these different combinations and permutations, hoping something's going to stick somewhere. And so far, nothing has. But as I said, they're playing the numbers game. They're hoping that they can appeal to some court, some judges that will say, you know what, let's let these cases go through, and then we kind of see what happens on the back end. But that's what, hopefully the U.S. Supreme Court in the Boulder case will make a decision that will affect all of these cases, that will lay down the rules of the road, and hopefully explain why these lawsuits are not viable, regardless of how the deck chairs are moved around.
Now, on the bright side, it keeps a lot of lawyers employed. So, can't necessarily say I'm totally against that. Right, Patrick?
Absolutely.
Well, Phil, I'm looking at the clock on the wall, and I think our time is slowly coming to an end. With the Supreme Court, or if there's any other action on this that's newsworthy, give us a call. We'd like to have you back on so you can explain what the ramifications of those decisions are to us. But this is a part of the show where I'm afraid, Phil, we have to say goodbye, Patrick.
Goodbye, Patrick.
Goodbye, Patrick.
Goodbye, Patrick. Phil, thank you so much for joining us. We look forward to having you on again soon. Thank you.
Thank you.